Thank you, ma'am. I would first request my online friends to first speak, and then we'll carry it on. Akash and Vinona, please.
Yes, I hope I'm audible.
Yes, Akash.
Yes, so a very warm greetings to honorable dignitaries and fellow discussants. My name is Akash Banyal, and I'm accompanied by Ms. Vinona D'Souza online on behalf of SLS Pune. We have 5 submissions to the Department of Justice that they may wish to consider for Vision India 2047. These submissions are based on our research with the support of CLCL Cell, an academic and research committee of our college. On affordability and citizen-centric approach, our first submission focuses on a complete rethink of legal aid clinics based on our legal aid cell's experience. The convention of bar and bench, it remains a colonial inheritance. Access to justice, therefore, makes access to the bar a sine qua non. However, access to bar is still not a developed notion for rural India, indigents, and the underprivileged. In 2015, in this regard, an empirical study was published by the Asian Journal of Legal Education that concluded that legal aid clinics at law schools were critical in providing access to justice. However, akin to US state practice, much more could be achieved if clients could obtain representation from law professors and final year or senior law students to assert their rights meaningfully. The national, state, district legal services authorities could arrange for some panel lawyers in this regard to supervise such proceedings. Other initiatives concerning legal aid clinics may include establishing a mediation center at legal aid clinics. And government departments and authorities can also help clinics elaborate their activities, wherein these ties can also help build a network amongst the legal aid clinics. On technology-enabled doorstep delivery of justice, our second submission concerns a paperless justice system with complete digitalization. Based on our law school's report on criminal justice system, the digitalization of the criminal justice system can be divided into 9 subportals. Firstly, a portal of citizens, a portal of investigation, a portal of forensic and computer forensic labs, a portal for medical practitioners, a portal for prosecution, a portal for lawyers of defense and victim, a portal for district legal services authority, a portal for judiciary, and finally a portal for interconnection of governmental departments. The Department of Justice may also wish to consider the case study of Republic of Korea, wherein for a smooth transition, the government used a paper on demand opt-in, not an opt-out system to allow the citizens to move from paper to digital. It also set up help centers that feature FAQs and tools for litigants. In this regard, for instance, a self-represented litigation homepage could provide information and templates about what needs to be done to file a case and respond to counterparties' claims without a lawyer's help. It would go a long way in making a digital system more citizen-centric and accessible. The ministry already has a thriving tele-law scheme. However, care may be afforded to develop a phone call-based mechanism similar to the one used for grievance redressal and customer service in the private sector. This is because the internet penetration and digital literacy rate in rural India still remains low. The critically acclaimed Malaysian My SMS system adopted a similar but a more primitive approach. The system allows citizens to access information on demand, helps government agencies broadcast information, and also provide a platform to give feedback and register complaints in government agencies. Even summons can be sent through the network. For our final submissions, I now call upon Winona D'Souza, who will speak on speedy trials and technology-enabled judiciary. Thank you.
Thank you, Akash. Very good afternoon to everyone gathered here. We are very grateful for the opportunity to present before all of you, and it has been very interesting listening to the suggestions made by my fellow students from other law schools. We have been invited, of course, to think outside the box, to imagine what the judicial system will need in 2047, and to reflect on everything that has disrupted the way we live our lives in the past 25 years. It goes without saying that one of our biggest disruptors has been technology. And the power of technology can, of course, be leveraged to improve and to quicken the access of justice in our country. The National Judicial Data Grid, a brainchild of the Ministry of Law and Justice and the Supreme Court's E-Courts Committee, is already an incredible step, to make sure that we have a national repository of data about the currently pending and disposed of cases in all district and taluka level courts in our country. This has made justice tech-enabled, it has made justice accessible and visible. The World Bank has even praised it as one of the manners in which the ease of doing business in India has improved. Along the same line, further mechanisms can be designed with the use of AI and machine learning to find similarities through the data grid, such that when a judge solves one case, it can help solve other cases which have similar issues and similar application of law. This integration can also provide with us software that can assist judges and judicial officers to identify what the relevant sections of law for each case are. We also propose that AI-based systems could be implemented during different stages of the case disposal system, such as pre-judging, judging, and support. AI systems can guide citizens on the basis of case analysis to understand what the relevant and the most appropriate steps are to solve their conflict. During the judging system, AI-based knowledge management systems can identify similar lawsuits and propose decisions based on precedents to facilitate decision making and make the process quicker. As for the support segment, AI systems could also identify patterns in cases texts, divide them, classify them in procedural documents. Now, of course, on the basis of research that has been conducted and based on the experience of other countries who have used such systems, there are concerns about ethics, about due process and accountability. And they have to be taken into consideration in the formulation of such systems and their inclusion in India's judicial system. The ministry may wish to consider that all coding of AI-based systems should invite technicians from different backgrounds to reflect the rich diversity of our country, and more importantly, to avoid any algorithmic basis or bias. It is also essential to incorporate meaningful human intervention through the ability to alter and override AI decisions at all points of the AI system process to ensure accountability. To conclude, we recommend that AI-based software should be deployed in a phased manner in the Indian judicial system, keeping in mind, firstly, standards of ethics, privacy, judicial integrity, and accountability. Secondly, ensuring that any such software is updated regularly through human intervention. Thirdly, that it is in line with Indian constitutional standards and also international benchmarks, such as the Ethical Charter of the European Commission for the Efficiency of Justice. And lastly, and most importantly, is not only introduced to judges and to judicial officers, but is led by judges, such that they are engaged and consulted in the design and implementation of technologies. With that, we end our presentation. We are grateful for the opportunity, and we are happy to assist in any manner possible in the ideation and the attainment of these goals for India 2047. Thank you, sir. I pass on to our representatives who are present physically.
Thanks, Sonona. So, in conclusion, we would like to raise two more points very quickly. First is that there is an excellent point in the PowerPoint presentation which talks about a ratio, and the statistic is that there are 21 judges, and every judge it represents certain million people. But I feel that there is one statistic which needs to be implemented, and that is with respect to criminal trials. So there is no statistic which talks about how many public prosecutors are there for representing litigants in India. And now I would like to refer to the thesis of my professor. He has compared the criminal system in India to the criminal system of France and other European countries. In those cases, the public prosecutors, they have a special power. And that power is that they can guide the investigating officer for conducting the investigation, one. And second, they can also go and conduct search and seizure. They can also supervise the entire investigation. Problem in India is that the public prosecutors and the investigating officers, most of the times they're not in, there's no good coordination between them, because of which the convicts, they get away, or they get a reduced sentence, or they get acquitted due to CRPC mechanisms. So that is why it's not an incentive, it's not a monetary incentive, but if we give public prosecutors more power by amending CRPC accordingly, then more people will be encouraged to become public prosecutors. That is one. Second is the NALSA is currently an excellent scheme, which is the NALSA paralegal volunteer scheme. And now this is with respect to a point which says that law students or that people should know the law, but how can paralegal volunteers help out? So that is a case is that bar council should effect a resolution stating that every law school in its fourth or fifth year, they should conduct a compulsory clinical course like ADRS or moot court. Similarly, a next clinical course, which would be paralegal volunteer training. And the PLV scheme allows for law students along with social workers to register as PLV volunteers. So if they register as PLV volunteers for one semester, they will be required to go outside and conduct legal awareness in underprivileged areas, rural areas, and that would ensure that people are from the marginalized communities, they get legal awareness. Now, just a week before, Symbiosis Law School Pune had conducted such an exercise, which was a barefoot law program in which we had called upon 25 women from the underprivileged areas, rural areas, and we had conducted a 3-day session in Marathi only. And we were able to provide them with general legal awareness. We collaborated with a local NGO. So, looking at these pointers, law students can also help out in their 5-year tenure and ensure that legal awareness is provided to everyone. And Mani, do you have anything else?
No.
Thank you.
One point I want to actually, the real point is all this discussion which has taken place, and people who have spoken online also, 70% cases in Indian courts, district and subordinate, are criminal cases which are pending. And why they are pending? Because PP is actually major issue, and police reforms which have not been taking place in this country is another major issue. So therefore, if India has to say lay down 180 days timeline, so at back end, those reforms, unless they take place in Indian society and Indian administration, nothing fruitful would be say availed. And the power of the basis that constitution which provides equality, two principles, rule of law and equal protection of law. These are written in our constitution. So if they have to be instilled in Indian society, the major reforms in investigation, in prosecution, in administration of police has to be carried out. Unless we may say in 2047, 180 days time is fixed for wiping out the case of a criminal case, it will not happen. In UK court, once I was sitting in the court, and after the proceeding I met the judge. Then I said that in our system, judge actually finalize in the first hearing or maybe second hearing what is the charge. But they were so surprised that how judge is involved in determining the charge. They say that in their system it is prosecution which brings the charge. And in Indian context, police always is habitual of charging excess. So over a period of time when criminal trial take place, some of the sections of various acts are removed by the court. So therefore, those tendencies are tendencies which actually are instrumental in delaying the ultimate case. So therefore, the core point of all this discussion is that major reform in criminal justice system and accountability of all those who are investigating, who are bringing prosecution charges to the court, unless it is determined, it would not be possible. So that is the core point, that major reform in criminal justice system entailing all these components is to be carried out. Thank you.
Very important issue has been flagged, because this is very intricately interlinked with the what we are thinking of, the kind of judicial system we are aspiring to have. Unless there is a commensurate reforms in the criminal administration system, the investigation, what you spoke of, the powers of public prosecutors, I think very valid point. Good, thank you.
Thank you, sir.